Welcome to Obsessed with Success, starring Russell Morgan.
Welcome back to Obsessed with Success. I'm Shameika Rhymes, and today we're joined by Alan Vaitzman, an associate at Morgan Legal Group who focuses on probate and estate litigation. In this episode, we're going to talk through Alan's background, how he built his focus in this area, and what led him to litigation. Welcome, Alan.
How are you, Shameika? How are you doing?
Doing well. I'm so glad to chat with you.
Excellent, excellent.
If you could walk us through your background and how you got started in the legal field.
Sure. So I graduated New York Law School, and then directly from New York Law School, I never wanted to be a litigator. I always told everybody around me I didn't want to do litigation. I want nothing to do with it. And then life just kind of unfolded. When I got out of law school, all of the jobs that I wanted to go into in terms of being a transactional attorney all wanted years and years of experience. My best friend's uncle, who was a partner of a firm, opened the door for me for litigation when I came to him with a request for a legal job. I was fresh out of law school. I had no idea what I was doing. So he allowed me to start on certain litigation cases, and that was kind of my entrance into the field. I learned there, I elevated, got better at what I was doing, and then transitioned out, and now I'm at the Morgan Legal Group.
What led you to Morgan Legal Group, and what stood out to you about the firm early on?
So I found Morgan Legal Group online, as I'm sure most people find jobs online. But what really caught me with the Morgan Legal Group was Russell Morgan. I had my initial interview with him. He seemed very and extremely professional. He knew his stuff. He knew names of judges, certain clerks. He was just a figure that I believed and knew that I can learn from and get the ins and the outs of specifically estate law and trust and estate litigation.
Wow. I've always wanted to ask this question. I know I watch a lot of legal TV stuff. Were there like any shows that you kind of watched to kind of help you figure out what area of law you wanted to go into?
So there was never any shows that I watched per
Okay.
se that would inspire me in terms of a field that I would go into, but
Hmm.
but there were shows that inspired me in terms of fields that I did not want to go into. So one of these areas is definitely criminal law. Um and it's not because I didn't think I was capable or I couldn't
Hmm.
do it. It was just the responsibility that a defense attorney has
Yes.
and what is at stake was just too high for me to be very, comfortable gambling, essentially.
Hmm.
If I wanted to protect people and I wanted to help individuals, I wanted to do it more on the civil side, just in case anything happens, something goes awry, it's not their liberty and their freedoms at stake. That was just something that, again, not that I wasn't capable of, I just didn't want to gamble with. And I give prize and praise to everybody that is in this field that is doing this for a living. My I I envy them.
Yeah, I didn't think about that. That's a great point. Yeah, there's when you brought that up, when you said there's shows that let you know which ones you didn't want to go in, I'm thinking, yeah, there are several things that I've watched over the years that I was like, I'm glad I didn't pick this path, or I'm glad I picked this path. At what point did you decide to start focusing more specifically on probate and estate litigation?
So before I came to the Morgan Legal Group, I was with the Levin Law Group.
Hmm.
And with the Levin Law Group, and this was my best friend's uncle, the partner of that firm. With the Levin Law Group, it really exposed me to a lot of different areas. I was doing Supreme Court litigation. I was doing eviction cases. I was doing partition actions. I was doing surrogate court work, of course. And in that firm, I was kind of a jack of all trades and a master of none. And I really wanted to hone down on a specific niche in the law. I wanted to be the best at something rather than okay at everything.
Okay.
So surrogate court work stands out a little bit more than any other field of practice because it is a lot more intimate.
Mm.
There's one or two judges per county. There's three or four clerks per judge. So once you're in this field, people start to get to know you. The clerks know your name, the judges know your face,
Mhm.
and it's a real intimate field of law. It's the same attorneys that you're going to see from court to court to court. So your name, it means a lot to a lot of people. If they know that you're one type of way, they already know who they're dealing with. So this enticed me and intrigued me a lot more than Supreme Court
Hmm.
litigation for the most part, because there's 20, 30, 40 judges per county in each different division, and everybody's just a number to everybody. So really, I wanted to hone down on surrogate court work. Plus, I was sort of good at it. So that was another element there.
So is that also kind of what made you decide the litigation side of this work versus estate planning?
Yeah, yeah. Estate planning is, shall I say, very transactional. It just, for me, it made me feel like a robot to a certain degree. It's You're pumping out wills, you're pumping out trusts, and I just think that my skill set in terms of talking to people, negotiating deals, getting settlements done, things of that nature, I was just a lot more natural with, and it worked out better for me. So I just thought that the transactional side is all fine and dandy, but I could just do more. I could just be more of an attorney than just, I don't want to demean anybody, but just pencil pushing wills and trusts out the door. I wanted to communicate. I wanted to talk to people. I wanted judges to know me. So I just wanted to elevate my legal career in that way.
Well, what did that learning curve look like for you early on when you started handling these types of cases?
The learning curve is heavy. It's
I
it's
bet.
it's it's a heavy curve. Um, Especially for certain individuals with public speaking fears. I also had that. I was never a big presenter. I didn't like to do class projects, but it
Mhm.
really kind of beats it out of you to a certain degree. And at some point, it's just like another day in the office.
Yeah.
When I first started, I was dreadfully scared to go in front of a judge, shaking in my boots, and
Mhm.
I'm still scared to a certain point till this day. And any attorney that tells you otherwise is just flat out lying. Every attorney is still nervous and is nervous to a certain degree to go in front of a court, to be on the record, to say something wrong, ask a witness, an inappropriate or wrong question that can be harmful. So there's still a bunch of nerves that get in there. And then of course, when you're drafting stipulations, there's always a fear of, did I miss something? Did I fully protect my client? Is everything in there that I need in order to settle this?
Mhm.
So there was always a curve in terms of opposing counsel as well. You don't want to sound silly or inexperienced to another fellow attorney that's on the other side, because then they could possibly take advantage of you. So you have to pull yourself up by your bootstraps. You
Mhm.
have to be very self sufficient. You have to do a lot of work on your own time outside of working hours to get better, to strengthen your defenses, strengthen your offenses. So there was a big learning curve. And for, I would say, to any attorney that's getting into litigation, to be comfortable, truly comfortable in front of a court,
Mhm.
easily 3, 4, 5 years down the line of experience that you have to have under your belt to feel truly comfortable.
Wow. Didn't even think about that. Again, I'm going by watching TV, but speaking in front of a judge sounds very almost intimidating. And when you're going through that learning curve, did you have, your notes? Did you memorize it? How did that work?
So when you go into court, unlike a classroom, you're
Yeah.
allowed to have documents and notes and statutes, so you can always reference it. Of course, brought those notes with me in the beginning, but usually in any field of law or any career, you usually see the same things over and over and over
Yeah.
again.
Hmm.
So eventually, the statutes that I used to bring to reference, I started to memorize. Certain petitions and certain writings I started to get more familiar with. So eventually it starts to be ingrained in you. But you should always prepare. You should always have a backup. In case you forget, you should always have a reference. Um, and yeah, there's just a lot that needs to be done in order to be, or to start getting very good in this sort of field.
Well, can you think of an early case or experience that really shaped how you approach this work today?
Yeah. So my motto in litigation is, you can never get what you don't ask for. So
Mm.
there was one of my cases where one of my clients came to us and he was getting hit by New York City with about $1.2 million in fines and violations for not filing certain RPIEs with the New York division of finance or HPD. I forget what it is, but
Mhm.
there's a filing that property owners must file if they own a certain amount of buildings or more. And he didn't file this for about 5 years.
Oh, wow.
The city wanted to hit him with about $1.2 million in fines. He appealed it internally and lost. And then we essentially sued the city via Article 78 petition for a court to review their decision as being reasonable, conscionable, so on and so forth.
Mm-hmm.
So during these negotiations, I went back and forth with my client about an offer that we can settle it with to not go through this whole Article 78 petition. And I shot out an offer of, I think, $50,000. Their attorney came back to me and said, we'll settle it for 70.
Wow. Big difference from
My
1.2 million.
client said, not a problem, paper it up. You'll have my signature by tomorrow. So it went from $1.2 million that my client was going to pay
Mm-hmm.
down to $70,000. And we set up a payment plan. He didn't even need to pay the full thing outright. He paid it monthly for a year. So my motto is, no matter what position you're in, whatever you're negotiating, if you want something, ask for it. The worst case scenario that, the opposing side can say no. And then you move on. But whatever you do not ask for, you're never going to get.
Wow. I think that right there is sound advice in any industry, I think, in all facets of life, honestly.
Absolutely, absolutely. But here it's a little bit different because you have to think about more than just yourself, more than how
Absolutely.
you will look on paper. You have to look at your client's best interests. So no
Mm-hmm.
matter what it is, no matter how low you think you're going, ask. Worst case scenario they can say is no.
What have you found to be the most difficult part of handling probate and estate litigation on a day-to-day basis?
To be honest, client expectations. So a lot of people, they think they understand how long everything takes from TV shows,
Mhm.
where, as you said, one episode, they filed the complaint. The very next episode, they're at trial.
Right.
Within 2 episodes, they're at trial. So a lot of these things kind of put this impression in people's heads that litigation, although they hear these rumors that it takes so long, they don't really understand how long it takes.
Mhm.
So managing client expectations is a very huge factor here. And this is another thing that I learned in probate and administration and anything to do in surrogate court is be conservative when you tell your client how long something will take. If you think it takes a week, tell your client 2.5. If you think it takes a month, tell your client 3 months. Because if you tell your client 3 months and then they get it back in a month and a half, they're super happy because now you've exceeded their expectations. But
Right.
there are also times, and what a lot of clients don't understand is that, as I said, there's 1 or 2 judges per county sometimes for the entire county, for everybody that has passed away, for every petition. So things sometimes get lost in the shuffle, and these clerks and these surrogate court judges don't have the time to get to, 500 cases a month, 700 cases a month, whatever the case may be. So managing clients' expectations is a huge, huge part of probate and administration litigation, specifically with how long you're presenting your client everything that is going to essentially occur in their case. Especially when somebody comes and they object and then they start causing problems, and then you have to go through a million conferences. So, at the beginning, when you retain the client, you're going to tell them this is going to take 2 months, and then one of their brothers or sisters objects, so now you're a year and a half into litigation. So it's all just about client expectational management.
What keeps this area of practice interesting for you over time?
The family dynamics. It's truly interesting to see how people of every creed act once they feel that a little bit of money is coming. And I will say that from my experience, the wealthier people are, the more they nitpick at funds. It's the people that are not as well off, that have better relationships, interfamilial relationships, shall I say, between brothers, sisters, aunts, uncles, where they've grown up together, they've known each other and have been on good terms for years. And it's the wealthy people that each live their own life, make their own money throughout their lives, where now when one family member has passed and they need to split an inheritance, everybody is nitpicking and is at each other's throats to get every last penny out of the estate. So the interfamily dynamics and mediations, and it's borderline therapy to a certain degree. You're talking to the brother, you're talking to the sister, the aunt, the uncle, and you're trying to bring everybody together in order to come to a mutual agreement about everything, because if they don't, the only beneficiaries of that estate will be the attorneys. Those are going to be the actual heirs of the estate and benefit from everybody, because all the money is going to be spent on litigation. So you're playing part attorney, part therapist, and you have all these different hats on, and you really need to know how to approach and how to angle your argument in a specific way to a specific person. This person may understand one sort of tone, the other person may understand another sort of tone, and you need to play that game in order to get everybody together.
Gotcha. Well, this has been such an informative conversation. Thank you for sharing your journey.
Absolutely, absolutely. I try my best to kind of get out there what I went through, so whoever is next in line can possibly take what I say, and with good faith.
Well, that's it for today's episode of Obsessed with Success. To learn more about Morgan Legal Group and their work in estate and probate matters, visit morganlegalny.com. Thanks for listening, and don't forget to subscribe, leave a review, and share the show with someone who might be interested.
Thank you, everybody.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.